You're welcome back. This is Newsfile. It's your most authoritative news analysis platform. And here on Newsfile, as always, we put Ghana first. And here is Samson's stake. Justice Atuguba on reforming the judiciary. So I'm just doing a reading of excerpts from a lecture delivered by the blunt-speaking patriot, Justice William Atuguba, at the University of Ghana on the theme, Protecting Our Democracy, the Role of the Judiciary. This was on Wednesday, the 24th of October. He talks about his lived experiences. So on the first topic, he says judicial admissions of executive intrusion of the judiciary. He begins by referring us to 1980, when the CJ, Justice Apalo, in paying tribute to the late Akufo-Addo, CJ, and President of Ghana, Justice Apalo said, quote, "One of the treasured qualities of a judge which he possessed and exhibited became his undoing." He's talking about Justice Akufo-Addo. He had the courage of his conviction and spoke his mind firmly. In a judicial decision which displeased the then power in the land, he was dismissed in February 1964, having been on the bench for less than 2 years. But merit, like cork, never remains submerged. Just over 2 years afterwards, he was returned to the bench to fill its highest office, Chief Justice. He remained in that office till August 1970, when he was invited to occupy a still higher office, the Presidency of Ghana. On the whole, he occupied high judicial office for just over 5 years, and did so with great distinction. Justice Atuguba says, quote, "There are instances in which it may be felt that some members of the judiciary pay allegiance apparently to the executive or otherwise instead of to Ghana. Despite the clear provisions of Article 146, a very knowledgeable Chief Justice of Ghana wrote on 2 occasions to a Justice of the Supreme Court terminating his tenure as a Supreme Court judge on the ground of ill health, without complying with the said Article 146. We all know that is Justice Pega he's talking about. On being shown the letters by the judge concerned, I strongly exhorted him to reply them, raising the contravention of Article 146. The same Chief Justice indirectly suspended me for 6 months by not empaneling me on any case immediately after I maintained my solo dissent in Chachuchikata versus the Republic, when it came up for review by the Supreme Court. Before I curtailed this issue, the same Chief Justice sidelined me as the then realistic most senior Justice of the Supreme Court, contrary to Article 144(6), who should act as the Chief Justice in his absence. I felt that since the Supreme Court is the custodian of the Constitution, I could not condone its infractions. I therefore assumed the functions of the Chief Justice with clearance from the then most senior Justice, who was then very seriously indisposed and handicapped, until I got to know from him very shortly afterwards that he had become fit enough to act as Chief Justice upon the death of the then incumbent Chief Justice." End quote. He then quotes the legal colossus, Dr. Dateba, retired, as observing the following in his book, and states, quote, this is from the book, "The appointment of judges, particularly of the Supreme Court, as the fulcrum of constitutionalism and the rule of law has its hiccups. It is the Judicial Council that recommends suitable lawyers or judges for eventual appointment by the president. Sometimes some judges are recommended by the Judicial Council to the Supreme Court over and above more experienced and senior judges, even though they are not more competent and experienced than their seniors. Often, when there is regime change, some of the sideline senior judges now get recommended for appointment to the Supreme Court through the same Judicial Council. But they then become juniors to their earlier juniors by reason of their later appointment. In practice, however, these later appointed judges often write the unanimous or lead judgments in difficult cases shortly after the appointment to the Supreme Court. Certainly, eyebrows can be raised over such practices. What can be the justification for such things? Nonetheless, depending to some extent on the judicial seizing, the judiciary has deepened constitutionalism in Ghana, notably the nullification of the 31st December holiday celebration funded from public funds, the freedom of choice of independent counsel by state bodies instead of the Attorney General. Despite Article 88(5), where there is conflict of interest, it says C. Amagache versus Attorney General number 1, National Media Commission versus Attorney General. As stated by Professor Dateba in his said book, constitutionalism is, quote, constitutionalism is about having limits to the powers of constitutional bodies and enforcing those limits, end quote. Now he talks about realistic independence of the judiciary. Here's an excerpt. He says, I want to emphasize that there is a vast chasm between independence of the judiciary in theory and its independence in practice. Thus, as explicitly stated by Dr. Dateba in his aforementioned book, quote, independence of the judiciary has two dimensions, the institutional and the personal. Professor Kukwazan loves to talk about this. Personal independence relates to the commitment of individual judges to the judicial values that ensure their impartiality and fairness. I am here referring to values such as eschewing corruption and not allowing ethnic and particularistic considerations to affect judicial determinations. Institutional independence of the judiciary, on the other hand, relates to the constitutional, statutory, and other arrangements put in place to assure the independence of the judiciary. Issues that are customarily dealt with under institutional independence include separation of powers, security of tenure for judges, including appropriate provisions on the appointment processes of judges, the conditions of service of judges, and the process for the removal of Superior Court judges, financial and administrative autonomy of the judiciary, and measures are what make judiciary independence justifiable. He says, quote, it would be unacceptable to have independent but unaccountable judges. Professor Kukwazan will love that. He concludes that, quote, in view of all this, what matters most is the realistic auditing and restructuring of the judiciary and indeed all other governmental institutions, because just as the cyanide of illegal mining galamsey has devastated forest lands and poisoned our water bodies, so also has the cyanide of political corruption poisoned our governance institutions. Appointments to the judiciary or any other governance institution must be made by thoroughly independent bodies based on nothing by merit and not on things like protocol, cronyism, ethnicity, and or other improper considerations. The governance institutions, particularly the judiciary, must be realistically insulated against presidential and other political pressures. Service conditions must be reasonably attractive, and security of tenure of office must be enshrined. The executive powers of the president and his functionaries must be drastically curtailed. He doesn't understand why the president has 4 nominees to the Judicial Council plus the Attorney General, 5 people who he thinks are policing the system, and therefore people may not be able to do what is right. There must be real separation of Parliament from the executive branch. The emphasis should be on good and sincere governance in the interests of the people and not on hollow, over-exaggerated notions of electoral conferment of power on anybody or group of persons. But no meaningful political reforms can be reasonably expected, even under a regime change, without sustaining the political renaissance which has started and is growing well in Ghana. That's Justice William Atuguba in a public lecture on protecting our democracy, the role of the judiciary at the University of Ghana on the 24th of October, 2024. Thank you very much. We will be right back. I'll introduce my guest and we get into the Vex Matters.